have we really arrived at a place in time in 2024 where nobody knows what a lesbian and a gay man is anymore?
If the Haldane judgment was right, then the entire category of sexual orientation falls away. The patients had to sign a declaration indicating that they fully understood that this did not make them a woman.
Oh, really?
So I'm a gay man. I'm not sexually oriented towards a piece of paper.
Right.
I think it's shocking in terms of what it says about the court's failure to understand the needs of women and failure to understand their rights.
They wanted to keep a functioning penis and still live as a woman.
That was a legal argument.
Yeah, it was accepted.
Hi everyone, here is my interview with Michael Foran, where we talk about sex falsification in law, where the law starts recognizing men as women and women as men. Earlier that week, Michael had been at the Supreme Court for the UK's big "What is a woman?" case. But this is not the first time that the "What is a woman?" question has come before the courts. The first time was in 1970 in the UK, and there have been legal challenges ever since, in the 90s, in the early 2000s. So in this interview with Michael, we're very much looking at the history of sex falsification in law, as well as the arguments made in the Supreme Court 2 weeks ago. We're going to do a separate interview to focus specifically on untangling the legal mess that we're in, where gender completely undermines the meaning of sex. I found the legal situation around all of this both baffling and fascinating, and found this chat with Michael really informative. So I hope you do too. Before we dive in, please like, subscribe, leave a comment. If you don't know what to say, just say, "No man can ever be a woman." And if you'd like to support my channel and me having these kinds of conversations, you can do so via Patreon or via PayPal. Okay, let's go. Hi everyone, I'm here with the one and only Michael Foran.
Thank you very much for having me, Menno.
And Michael is, what do you call it, a law academic, a legal academic?
Yeah, legal academic, yeah.
A legal academic. And you've already, for someone who's just turned 30, kind of done some influential things.
Yeah, I think I've had a good start to my career. Yeah.
So one of the things that you were involved in, perhaps inadvertently, was putting an end to self-ID in Scotland.
Yeah, basically.
How did that kind of come about? And what I know is that you wrote a blog post.
Yes, this was very much unintentional. Academics, legal academics in particular, were pretty much constantly writing about developments in the law. Were either writing long form things, or if you want to do something quick in response to something, you'll write something short like a blog. I wrote a blog post in response to a decision by the Court of Session about, actually very similarly to some of the questions we're probably going to be talking about throughout the conversation today, but effectively this was what we know now to be the Haldane judgment. It was the first decision in the Forum in Scotland appeal for the case, which was challenging the Scottish Government guidance that provided a particular definition of sex for the purposes of equality law, where they said that sex is not biological in equality law. Sex is modified by the Gender Recognition Act.
Right.
Sex is certificated in some way.
I have a quote for that. The definition of sex is not limited to biological or birth sex. So that was December 2022.
Yeah. So that was the first case in this saga that we're dealing with now. And that was, I think, 10 or 14 days before the final reading of the Scottish Gender Recognition Reform Bill.
Right, yes.
So up until that point, I think, an awful lot of people had a particular view about whether the self-ID was going to affect the operation of our anti-discrimination law that sets out not just the law that we would have in relation to, your employment rights, but also things like access to single-sex services, rape crisis centres, lesbian associations, things like that. And the Scottish Government line had initially been that the Gender Recognition Act doesn't affect any of these things.
Right.
And so changing the Gender Recognition Act, bringing in self-ID, making it easier for you to change your legal sex, wouldn't affect that either.
Whereas now they're actually, at the hearing at the Supreme Court this week, they actually argued the opposite, didn't they? Right.
And they were arguing the opposite back in December 2022 as well in that court. And Lady Haldane agreed with them. Lady Haldane said, "You're right. the quote that you just read out, sex is not limited to
Yeah.
biology.
We'll get into the history of how sex kind of became regulated to the lower regions of the law in a bit. But in terms of the blog post that you wrote,
Yeah.
what was it that made you go, right, I'm going to write a piece about it?
Yes, I mean, yes, I'm a legal academic. I teach mostly public law, constitutional law, human rights law, things like that. But my research is on those areas, but also in equality law. That was kind of the thing that I was focusing on for the early part of my career. So I had knowledge of both Scottish devolution law, the constitutional law around Scotland, what the Scottish Parliament is allowed to legislate on, what it's not allowed to legislate on.
Okay.
And equality law, which is a combination of specialisms that I would say would be relatively rare within the UK. And so I was following both the development of self-ID through the Scottish Parliament and this case.
Yeah.
And what I saw was an interaction that could occur between all the stuff that's happening there on that equality, what is a woman question, and constitutional law about what the Scottish Parliament can and cannot do.
Yeah.
And I basically floated the idea that there were tests in the Scotland Act for what we'd call now a Section 35 order.
Yes.
So Section 35 of the Scotland Act allows the UK government to exercise a veto on Scottish legislation.
So the Scottish government legislates for something, and then this is the mechanism for Westminster to go, no.
Basically, yes. And the provision there is, it's not unlimited. It's not just like any time the UK government wants to. There are very specific tests that have to be met. And they relate to whether or not what the Scottish government is doing was going to have adverse effects on the operation of the law that is within the hands of Westminster.
Yes.
So in this case, it was equality law. Westminster has said, the Scottish government, the UK Parliament has said that the Scottish Parliament is free to legislate on a whole bunch of areas, but it can't change our Equality Act.
You can go into any room you want, but not that one.
Yeah, basically, yeah.
And Scotland went into that room.
Yeah, well, yes and no. I mean, what they did was, the legal tests are complicated, but basically what they did is they smashed something through a window rather than went straight through the door.
Right, okay.
And so these tests had been met, basically. I argued that the tests had been met. I said that the Section 35 power had never been used before. It'd been in the Scotland Act. It was kind of lurking there in the background. Nobody had ever used it. And I put forward an argument that said those tests had been met and that the UK government could exercise this veto power as a result of that. And that happened to have been published on the final day of the reading, or the second day of the reading of the bill in its final form. And it was picked up by someone, I think it might have been the policy collective, Murray Blackburn Mackenzie.
Okay.
And they amplified it, and it ended up in being cited on the floor of the Scottish Parliament, where I think it was Pauline McNeill, who's a member of the Scottish Parliament, a Labour member, had said, the Scottish government has told us this isn't going to affect the Equality Act. And here we have this academic saying it absolutely will affect the Equality Act based on what Lady Haldane has said. So which is it? And the Scottish government didn't do anything that would provide for additional time to address something like that. So the bill passed in the Scottish Parliament.
Yeah.
And then, then there was a bit of a thing up in the air as to whether or not this power will be used. And Alistair Jack, the Secretary of State for Scotland, after the bill had been passed, released a statement saying that the UK government is not happy about this and that they will be looking at legal responses, including the possibility of a Section 35 order. So then I wrote a much longer piece over Christmas. I decided I'm just going to give up my Christmas.
So I was going to say, that's a great way to spend your Christmas.
Yeah, my mother was passing through plates through the door, being like, hope everything's going okay.
Do you like some pigs and blankets?
Yeah, basically. And so I wrote this larger piece as this was going on. And then while I was writing that piece, Isla Bryson was transferred to a women's prison. So Isla Bryson's biological
and then
male.
the whole thing kicked off.
Convicted of 2 rapes and then was put into a women's prison. And that, I think, solidified the political zeitgeist on that.
Yeah.
And then you had the legal power there. So I published that paper, and I think 2 or 3 days later, the UK government blocked the bill. And then the Scottish government challenged that. They said this was unlawful, not used the power properly, and that went to court.
Yeah.
And the court the same judge, Lady Haldane, upheld the lawfulness of that order. She said this was perfectly within the powers of the UK government.
Yeah.
So I think Lady Haldane gets an awful lot of flack,
Well,
but I think she's doing her job to the best as she could.
this is an interesting point because judges are there to confirm what the law says,
Yeah.
rather than what it should be.
Yeah.
Right.
It's not their job to decide what the law ought to be.
And I was watching, started watching a film yesterday called The Children's Act with Emma Thompson.
Oh.
Yeah, that just came up on my Netflix suggestions, and I
It's
thought,
that time of year. She's involved in a lot of films around.
well, I thought, especially because of the hearing this week at the Supreme Court, I thought, well, it'd be interesting to watch a movie about a judge having to make tricky decisions. And I even took a note of one thing the character said, because I thought that's interesting. Because we're going to be talking about the GRA in this chat, and whether that can be repealed or not, and how that works, or whether clarifying the Equality Act would be a better option, blah, blah, blah. And I want to look at just what does the law say before we look at what would we like the law to say.
Sure, yeah.
She said this court is a court of law, not of morals.
That's interesting because I don't think I fully agree with that. I think law is where we go to get justice.
Yeah.
But justice isn't just an individual thing. Justice involves principles of political morality. We recognize that we live in a democracy and that parliaments get to change the law, and they've done that on legitimate ways through process of democracy. And we might profoundly disagree with what parliament has done. But we're not the dictator here. We don't get to decide whether or not the rest of society has made the right choice. But there are limits on that. And courts are sometimes there to impose those limits. They will say, we're going to presume potentially that, ambiguous words in legislation are not going to take away people's rights. And in fact, this was a point that was relied on by both sides in the Supreme Court this week. So the Scottish government argued that the process set out in the Gender Recognition Act is a fundamental human right.
Right, yes. Okay, let's get to that a bit later.
Sure,
that was a really interesting point where I think they were talking about, okay, you've got the Gender Recognition Act, you've got the Equality Act, and again, that's just about acknowledging the law as it is.
Yes.
But to what effect does the Gender Recognition Act take effect? Is that just
and
for
how,
the purposes
how
of
are
that
courts supposed
particular
to
act?
interpret this?
Or is it across the board?
Yeah.
What this quote, the reason why I wrote it down is because she was making some very important life and death decisions. And she said, as much as emotions run high in this particular instance, the court is a court of law, not of morals. And to me that said, she's just there to tell you what the law says.
Yeah.
Nothing else.
Yeah, I mean, the fundamental job of lawyers and judges is to get the law right first.
Yeah.
And then to find ways to apply the law to the case before them.
Right. And there's an expression that another character in the film used, which I've heard quite a lot recently.
I'm afraid the law doesn't agree.
The law is an ass.
The law is an ass. Now, does that mean ass as in a donkey or a bum?
I don't know. And to be honest, I mean, I think that phrase is used a lot, and I don't think the people who use it care whether it means donkey or bottom.
And what does it even mean? It just means that the law is not on your side, or the law is just difficult?
I think there's some people who think, quite rightly, that the law can and has historically been used to do some pretty awful things to an awful lot of people. I mean, particularly if you're from the United States of America, institutional race-based slavery is pretty wicked. There are some things that are worse than that, but there's not many things that are worse than that. And you needed law to do that. Now, there's people who have different arguments about whether or not that really has the character of law. Maybe that's just, political violence backed up by guns. The state is just forcing this on you, and law has some connection to justice. I kind of fall into that camp. I think law has a connection to justice. But leaving that aside, I think, it's a very plausible view that people have that says, if you're a strong believer in the concept of patriarchy and that the law is an institution of our society, and our society is a patriarchal society, an awful lot of our law is going to be pretty crappy.
Which is something that Aidan O'Neill really highlighted in at the hearing
Yes.
on that first day. I was quite surprised by that.
Yeah, that I think that came to mixed views within legal circles, and it was very heavily supported by people who were watching, and I think it served a very important purpose. But we could maybe get into that as the conversation goes on.
So, you wrote the blog post that was mentioned on the floor in Parliament.
Yeah.
Then you wrote a longer piece, and the thing that you would argue for then happened.
Yeah.
Wow, that is.
Yeah, I mean, I want to be very, very clear to not try and take more credit than...
Right, it's not like you got a phone call from Westminster saying, "Oh, we read your piece and we love it."
Well, no, I did get an email from Alice Jack saying, your research and public writing on this has been instrumental to government decision making. So but what I mean is, what I'm trying to say is that
that's worth of a high five, right?
Look,
it's a very limp high five.
Oh, okay.
It's like
strong, manly.
In terms of that is a huge achievement.
Oh, it's great. No, don't get me wrong. I'm not saying that wasn't fantastic. What I'm saying is that was only possible because there had been women's rights movement in the grassroots that have been operating for years to bring this issue to political salience.
Yeah.
Making a legal argument that has no political salience doesn't get you anywhere.
Yeah.
Equally, making political arguments that don't have a legal way out might also get you nowhere as well. You need both, you know, and what happened with the Section 35 order was a successful grassroots feminist movement that was then able to feed into carefully calibrated legal arguments directed towards the same goal. And you really needed both of those to achieve what was done with that order.
Yes, your piece didn't come out of the blue.
Yeah, and if it had come out of the blue, if it had just been me writing that, it would have stayed on the Internet Archives. It wouldn't have had any significant
And
uptake.
NBM wouldn't have picked it up and...
Yeah, well, they wouldn't have existed if there wasn't a grassroots movement.
Right, because I don't know exactly when For Women Scotland was founded, but the first time that I was in Edinburgh outside Holyrood protesting against self-ID was September 2021.
Yeah.
And that was organised by For Women Scotland.
Yeah, they have been doing this for years. And I think, people need to realise that, the legal arguments are all well and good, but you really need to give credit to those women. They have done so much and they've sacrificed so much. They have been defamed and
relentlessly
castigated. Like they have gone through more than I think many people will ever go through in their lives. And I'm a legal academic. I'm writing relatively dry, boring legal analysis that I think is important, but I'm insulated because I'm an academic, not a campaigner, and because I'm a man, not a woman.
Because we're men. So it's
I've had a lot of pushback. I've had threats. I've had attacks on my employment, but I've no one's threatened to rape me. I've not had the kind of sexist abuse that these women have faced. So I think it's important to just kind of note that. I think.
Yeah, it's different from a Kathleen Stock situation.
Exactly. And part of that might be because I came after and people learnt lessons, but I don't think that's the only reason.
No.
I think there are other reasons as well.
I mean, I found the same. There's things that I can say. And obviously, I don't even want to use the word hate so much because that word gets used so much. I get some hate online, but it's nothing. It's nothing compared to what... I mean, look at Kelly J. Keane and what she went through in New Zealand. And then, again, recently was at Sheffield, where she had more tomato soup or juice products.
These are assaults. This is
right.
This is not
and
acceptable.
There was a guy making death threats who was actually convicted, but then they let him off.
Yeah.
Anyways.
The laws now.
The other thing that I personally appreciate about what you're doing is that you make the case for gay rights. And I think it was in 2022 at some point, you were... What do they call this? Giving a testimony to the Women Equalities?
I was a witness before the Women and Equality Select Committee. This would have been early 2023. It was after the UK government announced it was going to block the bill.
Right.
The Women and Equality Select Committee held, an impromptu, an emergency podcast, shall we call it?
Yeah. Was this Westminster or in Scotland?
Westminster. This was in Westminster.
Okay. Wow.
And it must have been, I think, a 3 or 4 hour session where we gave evidence about what the legal implications would be.
Right. And you specifically said that self-ID combined with the Haldane judgment is bad news for gays and lesbians.
Yeah, so this was, I think this was partially to do with the protected characteristic of sexual orientation. So
Yes.
we're protected under equality law.
Supposedly.
Yeah, well, I think we are.
It depends how you interpret the language.
Yeah, exactly. So the provision protects people on the basis of sexual orientation if they are sexually oriented towards members of the same sex, the opposite sex, or either sex.
Yeah.
So ostensibly that would be gays and lesbians, straight people, bisexual people.
Yeah.
But if the Haldane judgment was right, that sex in the Equality Act is legal sex or certificated sex or the sex that's on your government documentation, then the entire category of sexual orientation falls away.
Right. And this is one of the things that, because on the one hand, all of this can seem so complicated, and on the other hand, I think, but it's so simple.
Yeah.
Because if you say that sex is more than sex, more than sex. I'm sure there's a song in there somewhere.
I'm sure there is.
If you say that it's more than sex, then and that this bit that's more basically overrides, it negates the actual meaning of sex. Therefore, it turns both sex classes into unisex classes.
Yeah, and more than that, it breaks sexual orientation specifically because, so what I had said in the Women and Equality Select Committee was, I'm a gay man. I'm not sexually oriented towards a piece of paper.
Right.
And nobody is. Those categories make no sense. There's nobody who says, I will only be attracted to this person whose body will remain exactly the same if they happen to have a certificate I don't know exists.
Which you can't even ask about, right? We're sort of jumping all over the place. But it's interesting because yesterday, Wednesday. Mm-hmm. Wednesday, at the hearing at the Supreme Court, there was a person, and online the abbreviation for them was RC. So I don't.
Ruth Crawford.
Right, Ruth
That's
Crawford.
That's the lawyer for the Scottish government.
For the Scottish government, and she said something. I'm just going to read it out now as we're talking about it. She said something that I just thought, this is such an assault on what it means to be a homosexual, and we'll just jump to this straight away. Right. She said, at the Supreme Court, a woman at birth, oriented towards woman at birth, wouldn't be less attracted to someone who becomes a woman via a gender recognition certificate.
Wow, I didn't realize that's what she'd said.
Well, this is what I read on Tribunal tweets, and obviously they're typing really fast. So I'm just...
Yeah. I think if I remember the interaction here, this was about... the Scottish government was responding to arguments that if sex means legal sex or certificated sex, it would break the category of sexual orientation in the way that I've just explained there. And what she was trying to say was, in the Scottish government's view, that was what Parliament intended. And that it intended to include within the category of same-sex attracted people or same-sex oriented people, those who've got certificates who've changed their sexual orientation in law. And I think what ended up happening was there's a bit of a back and forth going on where Lady Rose, one of the judges, tried to clarify that what Ruth Crawford, the lawyer for the Scottish government, was trying to argue was that nobody is required, in order to be gay, to be attracted to every member of the same sex.
Yes.
They only have to be attracted to some members of the same sex.
Yes.
And there was a very interesting exchange then, because then Lord Reid, the President of the Supreme Court, interjected to say that that's all well and good, but that's not the point we're concerned about here.
Yes.
We're concerned about whether or not lesbian associations will be allowed to associate as lesbians.
Right.
And whether they will be required to include within their associations
a bloke who says he's a lesbian.
Who has a certificate that...
Yes, which you can't ask about, but we'll get into that.
We might get into that. And I think an important point to make about this is that it seemed to me that the this point about sexual orientation and about lesbian associations occupied the minds of the judges.
Oh, good.
They were very concerned about this. Lady Simler was particularly concerned about this. She interjected to ask Ruth Crawford about this, and Crawford responded by saying, well, you don't have to confine it just to sexual orientation. You could also be a gender-critical sexual orientation, so it could be gender-critical lesbians. And Simler did not seem impressed by this. She said, are you saying that they can't just be lesbians? They
Right.
have to be gender-critical.
Because essentially what she's doing is she's arguing against homosexuality. Because she's saying, because in terms of, because she did say, well, lesbians could have their own events if they're gender critical lesbian events, so on the basis of belief.
Yeah.
So already you're saying that being a lesbian, or you can't acknowledge what an actual lesbian is and just give the right on that basis.
Yeah.
Because some bloke might have a certificate, and it doesn't matter whether he's, because the Gender Recognition Act doesn't, it makes it clear that you don't need to have any medical interventions at all to get
That was
one.
something that really occupied the mind of the judges as well.
Right, because you could have a man with a beard and a penis, like yourself, and you may have a gender recognition certificate. And so for Ruth, if she meant it this way, for Ruth then to say that you would be no less attractive to a lesbian if you are legally female, that would be... I mean, it goes back to what was said at the tribunal when Mermaids took the Charity Commission and LGBT Alliance to a tribunal, where barrister Michael Gibbon KC challenged Kate Harris from LGBT Alliance on what a lesbian is.
Yeah.
And could the definition of lesbian not be more than, what everybody knows it to be? And then he asked her, can lesbians include someone who is a woman as a result of gender reassignment?
Yeah.
And Kate just broke down.
Yeah, I mean, that's a very tough question to, this is the kind of question that I think lesbians have been asked in one way or another for a very, very long time. And I think it can be particularly traumatizing. I do think that, I suppose I'll make two quick points. I mean, one, it seemed to me, anyway, from watching the response from the judiciary, the court bench over the Supreme Court case this week, that this is something that the Supreme Court is acutely aware of.
Right.
And part of that is because Karen Monaghan, KC, wrote an intervention on behalf of the lesbian interveners, the Scottish Lesbians LGBT Alliance, and several others. And Karen Monaghan is the undisputed authority on discrimination law. She's taken very seriously by the Supreme Court,
Right.
and they did. I think they took this point very, very seriously. The other point I'd make, just to come to Ruth Crawford's defence, a lot of people I think are thinking that because she was the one saying this, that she was the one who adopted this policy or believed it. Crawford is doing two things here. One, she is presenting an account of what the law is, according to the Scottish government. And two, she is representing her client. And I think she's getting a fair bit of personal attack for something that barristers and lawyers are expected to do, which is to act in the best interests of their client.
Yes, but then I guess this would be a whole other conversation, and I guess a bit more philosophical about how you interpret your role as a barrister. Because if you're there to argue against what homosexuality is, how can you do that in good conscience?
Yeah, so
It's a question I would ask.
So I think I can make a bit of a response to that, which is
and does she even realize that she's doing that? Because that Michael Gibbon guy, the KC, when he saw Kate Harris's reaction, then they adjourned for a bit, and then afterwards he asked her if he'd inadvertently said something to upset her. And I'm like, how can you not realize that you're basically asking a lesbian to accept a man as a lesbian? How can you not realize that that's what you're doing?
I mean, some of this could genuinely just be ignorance. I think one point I'd make is that there is ethics when it comes to what barristers do, and sometimes barristers cross that line. Sometimes they go beyond that in badgering witnesses in cross-examinations that are too harsh. They can do things that are unethical as professional ethics would deem. nothing Ruth Crawford did was anywhere close to that line. She was representing the defensible legal argument that her client wanted her to make. And it is a defensible legal argument. It would not be an argument that I would support for moral reasons, and it's not an argument that I support for legal reasons. I think it's incorrect, but it's plausible. And her job is to present the best plausible legal
Argument,
claim for her client. I don't think she crossed any ethical lines. I think it's right that people were offended by the implication.
Yeah, I mean, as a gay guy, I get quite emotional about these things, where you're like, have we really arrived at a place in time in 2024 where nobody knows what a lesbian and a gay man is anymore? Similarly, as lots of women are like, why do we have to go to court to clarify what a woman is?
Yeah, and the answer to that is that the law has, for the last several decades, well, that might be true, but for several decades, the law has had a complicated answer to that question. It's not as simple as it used to be, and that may be something to lament, it may be something to fight against, but if your job is to describe the law or to argue what the law is and to apply the law, those are different questions.
Right, so that kind of leads us nicely into what I call sex mimicry as a human right. That's not a term that everybody uses, but I just think there's so much talk about gender this and gender that. I'm like, let's just use real plain language, because at the end of the day, it's about whether the law recognizes a man living as a woman and a woman living as a man. And the law does internationally acknowledge this. So when I had a look at this, as part of my research for some of the videos I've made, the first example I found was 1930, where Lily Alby was declared legally female with help from the Danish king.
Yes.
Right? Because oppressed. And then in the UK, it was 1944, where a woman called Michael Dillon had her birth certificate changed to male.
Now, that's interesting. So in the UK...
Because obviously over time the mechanisms have changed.
Yeah, so before the Gender Recognition Act, the only way that you could get your birth certificate changed was if there was an error in the initial recording.
Okay.
And that was in the context that we're thinking about here, the kind of male to female change or female to male change. That is, as a matter of law, that has historically been circumstances where someone has been born with a DSD, with a disorder of sexual development.
Yes, so I don't know what the specifics were or what the justification was for Michael Dillon to have her legal sex changed. And I'm saying legal sex because this is a concept in law. So obviously, for any viewers who go,
we're talking about the record on the birth certificate.
Right.
Yeah.
And
that's a legal concept.
That's a legal concept. Yeah. So the falsified sex, if you like.
Yeah. So up until 1970, the only argument that you could run legally was that there'd been an error on the birth certificate.
Right. And this is the argument used by Roberta Cowell in 1951. So in the UK, the first one that I'm aware of, and again, I don't know the specifics of how they pulled this off, but Michael Dillon had her birth certificate changed to male. In 1951, Roberta Cowell had his changed to female, but he used that argument of having been born with a DSD.
Yeah.
And he actually, in today's terms, would be considered anti-trans because he kept wanting to distance himself from other men who wanted to be seen as a woman because he's like, well, I had a condition and you don't, and leave me alone, kind of thing.
Yeah, I mean, I think the law up until this point, up until 1970 is when Corbett and Corbett comes in.
So 1970 was kind of the first legal case where the court had to decide what is a woman, and this was all about someone we know as April Ashley, who was married to some kind of aristocratic
Arthur Corbett. Yeah. But the question was whether they actually were married.
Right, because obviously in those days same-sex marriage wasn't a thing.
Yeah.
And wasn't it about them getting divorced and April wanting money or something?
Yes, I don't think it was a divorce. I think what happened was...
annulled. It was annulled.
Yeah, so about 2 weeks after they were married, April left and never looked back because Arthur Corbett was a nut job.
Okay.
And if you look at the actual So if you look at the transcripts, I mean this is certified. If you read the facts in the case, Corbett was in the judgment. This is not something that we're finding outside of the court record. This is in the court record that Arthur Corbett was what we would describe now as an autogynephile. He was erotic.
I remember this. Yeah.
He was erotically fixated on changing sex, and he saw April Ashley as the first person to have successfully undergone that surgery.
Yes.
And so the quote that's used in the judgment is, "Here was my fantasy brought to life and standing in front of me." So Corbett was, and so much so that Corbett was married and had children, and would bring April Ashley to meet his family. This is not a healthy situation that's happening around here. And so when he divorces his wife and abandons his family in order to marry April Ashley, about 2 weeks after that happens, April leaves and never comes back until a year or so later, when April decided, "I'd quite like that villa in Morocco and maybe some maintenance payments." At which point Arthur Corbett says, "You're getting nothing. We were never married.
You didn't let me wear your dresses."
The argument that ended up before the court was whether they were actually married.
Yes.
And that depended on whether or not April Ashley was a man or a woman.
In the eyes of the law. And there's a quote that I have.
You were very well prepared.
I spent my Christmases doing lots of interesting things. Right. So 1970 was an important point, because it was the first time that a judge said, this is what sex is, and this is how the law should treat sex, which is you have to look at the chromosomal, gonadal, and genital tests. Mm-hmm. And then if that's all congruent, that was the language they used, I think, you base it on that. And you ignore any operative intervention.
Yeah.
So surgery doesn't make any difference.
Hormones don't matter, and psychology doesn't matter. So
right.
One of the arguments that was trying to be run in the run-up to this. Yeah. So maybe just a little bit of context, from people with intersex conditions have been around since humanity has been around. Mm-hmm. And the law has had to deal with that reality since the time, as long as we have had law that differentiated.
Yeah. And it's only recently that we've started learning more about it.
Yeah. But we had law about it, and the law said that if your sex was indeterminate, we don't know what your sex is through the ordinary means because there's some anomaly of some kind. And bearing in mind, we're talking about, this can go back as far as ancient Rome, these same laws existed.
Okay.
You would take the sex that was more dominant.
Yes, or at least that's perceptible. I guess.
And so all of these earlier cases where people were attempting to get their birth certificates changed because they claimed there had been an error on the birth certificate, the cases that had succeeded because they presented evidence to the relevant legal authority that they had an intersex condition.
Yeah.
And the ones that failed had failed because they couldn't provide that evidence. Yeah. And so the argument that some were trying to run at that point was that transsexualism was a form of psychological intersex condition. And so but that was a very clever legal argument because it engages these rules. It says you take the more dominant sex, then you add in the fact that individuals have then taken exogenous hormones and they've undergone surgery. So what April Ashley was saying, the argument that was being run was that transsexualism is a form of psychological intersex.
Yes, and this is an argument there's a documentary it's not a documentary, it was a BBC show, 1973, which was the first ever TV show where they got 4 blokes with their magical lady feels to discuss amongst themselves what it means to be a woman. Mm-hmm. And even then, the guy who sort of ran the whole thing said,
"This question should be taken out of the medical field. The doctors will argue quite sincerely about what is a man or what is a woman till the cows come home. We should do as I believe they do in France. They say sex changes should have all the legal rights as women. The law doesn't have to say they are women, but they should be treated as women, because we live in a a two-sex society with only men and women. These people obviously can't be regarded as men, so give them their full rights and not treat them as second-class citizens, as concubines. Treat them as women."
They also had an MP, a Welsh MP, I forgot his name, and again, it's 73, he said there need to be proper, for this surgery specifically, need to be, and the diagnosis, need to be safeguards in place, because you might inadvertently end up getting what he called effeminate homosexuals going down that path for the wrong reason.
Oh, that's interesting. I didn't know.
Yes, but
So
the main one who ran the panel also made this argument that really we're all intersex. Every human being is intersex, but we just, it's a spectrum, and we just fall on different.
Yeah, so like the argument that was being put before the court in Corbett was we've got a legal rule to deal with this, which is indeterminate sex.
Yeah.
And we've got a mechanism to deal with this, which is the answer to the question is that you take the more dominant sex.
Yes.
And April Ashley has undergone surgical intervention to make one sex appear more dominant than the other. So that should trigger all of those old, ancient legal principles.
Right.
And basically say once you've gone through the surgery, you will be legally recognized. And the court flatly rejected that. The court considered all of those things. And I mean, this is just a general point maybe for those, sometimes you hear this argument of like, how could a court possibly identify what sex someone is? And the answer is we've had that question. That question was asked and answered in 1970. You present evidence. If your sex is relevant for a legal case, as it was in April Ashley's case, where the individual sex matters for determining whether or not this was a valid marriage. Yeah. Then if someone contests that, which is what happened here, Arthur Corbett said this person is not female. Then that becomes a relevant question of fact to be determined by the court. And the way you determine that is by each party presenting evidence. Right. And April Ashley presented a lot of evidence, and there were medical examiners who came in and looked at all of this, and including evidence that the doctors had provided that said that, when they approved people for gender reassignment surgery or sex change surgery, or whatever we want to call the surgery, the patients had to sign a declaration indicating that they fully understood that this did not make them a woman.
Oh, really?
So they had to sign a declaration that said this is treatment for a medical condition.
Yes.
It's treatment for severe distress caused by this misalignment between what you'd like your body to look like and what your body actually looks like, and it will not make you a woman. So as a matter of the legal transcripts there, we had all of this background kind of medical information and evidence that was put forward, and the court considered all of it, and Arthur Corbett said biological sex is immutable, it's fixed at birth at the latest, and it's real.
That's what Arthur said, or the judge?
That's what the judge said.
The judge, yeah. So, and he actually said that April Ashley had at all times been a biological male. Yeah. I mean, I love reading that. And I'm like, we need him to come back to be here at the Supreme Court. The next case then, so that was 1970, and it was very clear you're a bloke in sort of blunt language. Yeah. Then in 1991, it was Caroline Cossey who tried to get recognition as a woman, which failed. Yeah. Initially, he succeeded, but then the UK government appealed, and then he lost. And then I don't know what he did after that. But the next one I found was in 1995 in New Zealand, where it was the Attorney General versus the Otahuhu Family Court. So this is 1995 in New Zealand, where they basically, I've got a bit more information about it right here. Because a lot of people think that all of this is sort of recent, but it's not. This has been going on even in legal environments for decades.
It's been a long time. I mean, the thing that's quite recent is the shift away from tying all of this to surgery.
Yes, this was a key point. So in 1995, they said, and I'm just reading this out, this is not my choice of language. Once a transsexual has undergone surgery, he or she is no longer able to function in his or her original sex. An adequate test is whether the person in question has undergone surgical and medical procedures that have effectively given the person the physical conformation of a person of a specified sex. And I find that and that's why I call it sex mimicry, because it's about physical conformation.
Yeah, I mean, another case that relates to this is A and Chief Constable of West Yorkshire Police, which was It actually featured a lot in the Supreme Court hearing. It might also be relevant for thinking about one of the questions I know you want to talk about, which is whether repealing the Gender Recognition Act is a good idea or a bad
What year
idea.
was this?
This case was 2004.
2004.
So it was just before the Gender Recognition
Yes,
Act came
okay.
into force. And it was a case involving a transsexual male to female individual who'd undergone surgery who wanted to be a constable in the police force. And legally this was a man. There was no legal recognition for sex changes here at this point. We didn't have the Gender Recognition Act, but we did have European Union employment law that said you had to protect people from discrimination on the basis of gender reassignment. And
So this was already a legal concept before the Gender Recognition Act?
Yeah, we had this since the 1990s, and that law didn't say that you could necessarily change sex. What it said was that you couldn't be fired for telling your employer you would like to change sex, or that you're proposing to do so, or that you're going under an operation or something like that. You could be fired for that, and you couldn't be denied service because you look like you might be about to change sex, or So this covers gender non-conforming people as well. But what we had basically was that, and we had the Goodwin case, which was the first time that the European Court of Human Rights held that for post-operative transsexuals, there was a requirement to provide some mechanism of legal sex change. That had to happen.
Yeah.
As a matter of...
What year was this, Goodwin?
Goodwin was 2002 or 2003, so it was just before the Gender Recognition Act was passed in order to give legal effect to the Goodwin decision.
Right, yes, but also there was a case in 2001 in Australia, which was actually not the case of what is a woman, the case of what is a man.
Oh, interesting.
So, and in that judgment, they basically said self-perception and life experience should also be considered when you look at what does sex mean in law. And again, I'm just quoting, post-operative transsexual people will normally be members of their reassigned sex. So that was appealed, but that appeal was dismissed.
Yeah.
And the judge, Mr. Chisholm, he concluded that in this case it was what is a man. Man includes, as a question of fact, post-operative female to male. It didn't deal with the question of pre-op.
Yeah, or identity. So this is a time period when the law is only dealing with people who've gone through these surgeries.
Yes, surgery was key to all of this.
And so in A it was more than just surgery. So the reason why A was denied employment was because the Chief Constable of West Yorkshire Police determined that in order for you to be a constable, you have to be able to strip search people. And a post-operative transsexual, male to female, cannot strip search women because they're male.
Yeah.
But also probably couldn't strip search men because they look like women. And
well, some, maybe, a little bit. Again, this is in the eye of the beholder, I guess.
Yeah, and this is the point about the perception. And so basically what happened then was because because A was denied employment, a lawsuit was brought on the basis that this was discrimination. And West Yorkshire Police wanted to say, we have an exception here. These are genuine occupational requirements. And the House of Lords, which at that point was what we would now call the Supreme Court, so not the upper chamber, the legislative chamber, but the court.
Okay.
They considered this, and I mean, this was a really shocking decision.
What decision?
A shocking decision.
Shocking, okay.
The court said that a post-operative transsexual who was visibly and for all practical purposes indistinguishable from a member of the opposite sex.
Yes, someone who passes.
Should be treated effectively for all legal purposes as if they are of that sex.
Yeah.
And then the court said, Lord Bingham said that in those circumstances, no reasonable objection could be given by a woman to being strip searched by a post-operative male to female transsexual.
Wow.
Now, I think that's shocking. I think it's shocking in terms of what it says about the court's failure to understand the needs of women and failure to understand their rights. The law has moved on since then.
Well, I just want to take you to something that Jane Clare Jones once said at the LGBT Alliance conference, which I keep going back to because I don't think anyone has ever put it as succinctly as she has. She said, "This is the only movement that is demanding legal recognition as other classes of people who already exist." And I wonder, like how many of these legislators and these judges actually realize that this is...
I don't think that was in their minds at all, and I think it's important to
because that is the key to it, right? Because so much of this talk is about how do you balance the rights of different groups of people, but here we have one right that neuters the rights of another.
Well, so this is one of the interesting points that was relevant for the Supreme Court case, actually. So maybe to give you the timeline that could be relevant here. So we have.
Shall we just finish off the Goodwin thing first?
Well, this is
right.
The
okay.
So we have this case. Goodwin has provided a requirement on the UK to bring in some system of gender recognition.
So Goodwin took West Yorkshire Police to court.
Oh no, Goodwin was a different case entirely. I think Goodwin was a bus driver. Goodwin took the UK to court in the European Court of Human Rights and won. The Goodwin case placed an obligation on the UK to do something to bring about legal gender recognition for post-operative transsexuals. And we also had European Union anti-discrimination law that was relevant here as well. And what happened basically, because we had the Human Rights Act, this is legislation that we have that requires courts to take into account the jurisprudence of the European Court of Human Rights.
Right, so you've got the European Convention of Human Rights, and then the UK passed the Human Rights Act in 1998 in order to put that European stuff into UK law.
Yeah, into a domestic footing.
Right.
And so a lot of this is about UK human rights law rather than European human rights law.
Yeah.
It's not international law here. We're now talking about the domestic law that's applicable here. But basically what you had was legal requirements to do something in the realm of legal sex change, gender recognition.
To somehow accommodate people who've gone through these procedures. Yeah.
But what exactly you had to do was a matter of discretion. There was more that could be decided here.
Yes.
And in the absence of legislation, the Gender Recognition Act, the courts were the ones who were filling this gap.
Right.
And the way the courts filled that gap is exactly how I've described it in A and Chief Constable of West Yorkshire Police. They said, effectively a very narrow walkway, they said, you have to meet a pretty high standard, which is you've gone through the full surgery, whatever that is.
Yeah,
and you are
full English.
And you are visibly and for all practical purposes indistinguishable.
You have to.
And after that, you basically get everything as a matter of law. You can strip search a woman who doesn't consent to it.
Yeah.
Or who couldn't consent to it because she's been deceived. So that's what the courts were doing.
Yeah.
And Parliament did something different. The Gender Recognition Act did not go that broad. The Gender Recognition Act made it easier for you to get this legal recognition. You didn't have to go through surgery.
Yeah.
You had to be diagnosed with gender dysphoria. You had to live as a member of the opposite sex
for 2 years.
Yeah. And that point became relevant in the Supreme Court, so we can talk about that.
And you had to say that you committed to living like this until the day you die.
Yes. So those are the three things you had to do. And then you didn't get what A was going to give you, which was a complete blank check to be a member of the opposite sex.
Right, because I think this may have been taken out when the Equality Act came into to being, if you like. That even in the Gender Recognition Act itself, there was an exception for sports.
Yes, so
I thought this is interesting because even the Gender Recognition Act itself acknowledges that a man with a certificate that says female is not a female.
Yeah, as a matter of fact, absolutely. The Gender Recognition Act, I mean, I understand why people on the gender critical side of this debate are very, very committed to repealing the Gender Recognition Act. But one thing just to be aware about the Gender Recognition Act is that it was a less extreme version than what we had immediately before the Gender Recognition Act, which is what the courts were doing.
Which is what the courts were doing. I mean, in Holland, I think they created a new law in 1985, which would be the equivalent to the Gender Recognition Act here.
Really?
In Germany in 1980.
I didn't know that.
In Sweden in 1972.
You're far more educated than I am on the international.
This stuff has been going on for a long time, I guess is my point. And when you get a big, powerful country, obviously this was West Germany at the time, and then Holland in 85. So we had a change to what's colloquially known as the transgender law, which is a real misnomer because it's not a law that's specifically for a small group of people in the gender corner over there. This article in our constitution decides how sex is treated across the board. So it should be called the sex law.
Yes.
But they call it the transgender law.
Yeah.
I mean,
law.
And it was changed in 2014 to take out any requirements for surgery and hormonal interventions. The Dutch government has even paid reparations to those who've been sterilized because of the surgeries when they didn't really want to have their surgeries. So
I think that's probably right. I think forcing people to be sterilized is a human rights abuse.
Yeah, I mean, I don't think that you should be able to falsify your birth in the first place, but this was, and internationally there was pressure from the international sort of lobby groups saying that the Dutch government was transphobic, this and that. But you know the drill.
So if we just look at the Gender Recognition Act, I mean, that had a mechanism that didn't require surgery, but it also carved out huge exceptions. I mean, it carved out exceptions for sport, you're right. It carved out exceptions for sex-specific criminal offences, for parentage, for inheritance, and it had a generic carve-out in Section 9.3 of the Act that subject the Gender Recognition Act's provisions to provision that had been made either in the Gender Recognition Act or in any other act.
Right. So, I mean, I find all of this as frustrating as I find it fascinating. So I just want to have a recap of these, because there was also the Bellinger or Bellinger?
Bellinger and Bellinger, yeah.
Bellinger and Bellinger, so that was 2003, so again, just before the Gender Recognition Act, which is considered to be a landmark trans case, again, about whether a guy was validly married to another guy. And the European Court of Human Rights found that the UK law was incompatible, to be precise, Section 11C of the Matrimonial Causes Act 1973, with the European Convention of Human Rights Act, Section 4, Article 8 and 12, which is about the right to privacy and the right to marry.
Yeah.
So this was the UK Parliament then pushed for the legal, the legal framework to be created, which became the GRA. So you had the Goodwin case, the Bellinger.
Bellinger and Bellinger. That confirmed two things. The first is that as a matter of our common law, domestic law, sex is biological. That was the thing that the court absolutely confirmed.
Oh, good.
But then it said, that could be changed by legislation.
Right.
And that is what Parliament did.
Okay, so I read a big fat PDF document about 12 pages, basically. So, okay, now I understand. So there were 5 judges in the House of Lords, and they gave their judgment. And I read that judgment in preparation for this talk. God, you just never stop reading, do you?
It's
and they were saying, okay, the law says sex is just what sex is, but that means that there's something missing for people who want to jump ship, basically, and something should be put in place. Right. But what was interesting is all 5 of them highlighted how what an impact being able to change your legal sex would have on other groups of people. They foresaw lots of issues. But I guess that's a whole other conversation. How did the GRA even come to be, and how did those discussions happen, and how did it end up in the form that it did? Yeah. But just because we've been talking for an hour already, we haven't even got to the 4 Women Scotland hearing.
We should probably get to that.
Yes. Okay. So we get to that next. But it's just to show you that there's such a history to all of this, and obviously we have the Tickle versus Giggle judgment in Australia. What was it? September when did that come through? Well, around that
Yeah.
time, or October,
Into the summer, I think. Yeah.
where basically this bloke Roxy Tickle is considered to be female in the eyes of the law, and therefore actual females have no way to say no to a bloke like that. So yeah, we didn't end up there just like that.
Yeah.
There's a whole history to it.
Yeah.
And it's organizations like For Women Scotland, and now of course Sex Matters, LGBT Alliance, Scottish Lesbians. I think there was another lesbian group involved.
Yeah, there's a collection of lesbians that are collectively now called the Lesbian Interveners.
The Lesbian Interveners.
Yeah.
And you know they don't mess about.
No, they do not.
So they're now really pointing out what a mess it becomes if you give gender the upper hand, I guess, in law.
Yeah, I mean, the thing that prompted this in form in Scotland was an attempt by the Scottish government in the form of guidance to establish clearly, in their view, that sex, for the purposes of anti-discrimination law,
Yeah.
isn't biological sex.
Right, and this started in 2018, at least with this Gender Representation on Public Boards Scotland Act.
Yeah, so that's the key piece of legislation.
Wow,
that's
so it's
relevant.
6 years.
Yeah. Court cases take an awful long time and a hell of a lot of money.
And again, this is where I just want to say if they ever happen to watch this, I just want to say thank you to these women who've taken this on, and for 6 years to be fighting this battle,
Yeah.
to take it to the Supreme Court.
And I think it's of particular importance, not just because of the underlying relevance of the issues that we're dealing with here, but also this is an area of law that I have not seen so much misrepresentation, concerted attempts to obfuscate the law.
Looking at you, Robin Moore White. That's me saying
I
that.
make no comment. But I mean, I think organizations such as Stonewall are being sued for this very point right now, for the way in which they have induced others to break our anti-discrimination law.
Yeah.
And so, the importance of this case, I really think can't be underestimated in terms of a clarification of what our law actually does provide in terms of protection from discrimination on the basis of sex, in terms of the recognition of sex as a biological category in law. And that's the central issue in this case, is whether for things like the representation of women in our society, things like anti-discrimination law, women's single-sex services, whether the law really genuinely intended those to be biological categories or not.
And that was one of the key points from the hearing, what the intention was, right?
Yeah.
Right, okay.
Yeah, so the central argument here is did Parliament, when it passed the Gender Recognition Act, intend to change the way anti-discrimination law works? Did it intend to change the way women were constituted for the purposes of equality and anti-discrimination law?
So the other question, I guess, is when the Equality Act was enacted, did that take into account the Gender Recognition Act?
Yeah, and interestingly, both parties to this case claimed yes.
Okay.
So the Scottish government said Parliament knew the Gender Recognition Act existed when it passed the the Equality Act, and it didn't make any express or clear carve-outs to disapply the Gender Recognition Act. So Parliament can be taken to have intended, when it passed the Gender Recognition Act, when it passed the Equality Act, to have intended woman to mean this, artificial
The broader, the fiction, or
Yeah.
the legal fiction.
And both For Women Scotland and one of the interveners, Sex Matters, argued that Parliament clearly can be taken to have understood that the Gender Recognition Act existed. And when it passed the Equality Act, it restruck the balance between sex and what we describe now as gender reassignment as a protected characteristic, which would cover most but not all people who identify as trans. And so what, in particular, Sex Matters was arguing was that whatever Parliament intended when it passed the Gender Recognition Act, whatever it intended to do to anti-discrimination
Was overridden by the Equality Act.
Yeah, and what the Equality Act does, its purpose is to set out a balance of rights between these competing groups. And I know there's some people who think, there should be no recognition of these rights at all.
Yeah, but again, we're just looking at what the law is rather than how
what
we
did
want
Parliament
it to be.
actually do.
Yeah.
And Parliament did not abolish the Gender Recognition Act when it enacted the Equality Act. It didn't remove the protected characteristic of gender reassignment. Those aren't options for accurately describing what Parliament did. So you have two options. Either when Parliament enacted the Equality Act, it intended certificated sex to be read in every time you mentioned sex.
It sounds so stupid, doesn't it? Certificated sex.
Well, this is effectively what Aidan O'Neill, the barrister, he just said, this is just absurd. And the barrister for Sex Matters took a more cautious approach and said, this is complicated, but here's a way through. And so both of them worked in different ways, I think, for running this argument. But they were both relying on the idea that when Parliament enacted the Equality Act, it meant for sex to mean biological sex.
Yeah.
And if it means anything other than that, you break the act.
Right.
Parliament never intended to break its own legislation.
Right.
That's the central claim that's being made on that side. The argument here is that the intention of Parliament was to strike a balance between these relevant groups, and that didn't require compromising women. And Aidan O'Neill for Foran Scotland very powerfully made that argument and said, the presumption here cannot be, with vague words like what the Gender Recognition Act did, that you can strip women of their fundamental human rights.
Right, it's the fundamental rights, isn't it? It's the right of women to be recognised as a sex class.
With that, their identity rights that will be contained within,
And men, and gays,
yeah,
and lesbians.
yeah, but also their right to privacy, their right to freedom of association, the right to freedom of speech. There's a whole bunch of things, and the Scottish government was trying to argue that the Gender Recognition Act itself enshrined a fundamental human right for trans people to be identified in their legal sex. That, I think, is not going to be as compelling an argument legally or doctrinally because those rights are qualified. They have to be subject to a balance. And so the same thing can be said for right to freedom of association, right to freedom of speech. And so you get into the question that fundamentally comes back down to this, which is, what did Parliament intend here? Did it really intend to, for a gender recognition certificate to override everything in the Equality Act, including the protections that biological females, women who identify as men,
Right,
become pregnant. There's a whole bunch of areas here where the court will have to, if they adopt the Scottish government's argument, they're going to have to accept that Parliament intended quite a lot of very absurd things.
Aidan O'Neill made a very interesting point where he said that men with a certificate will gain, but women with a certificate will lose.
Yeah, the argument here is basically that women with these certificates lose protections that were specifically intended to carve out specifically for women.
Yeah.
The Equality Act doesn't have anywhere that's just for men. It has areas that are for men and women, so you can't be discriminated against on the basis of your sex. You can't be denied access to employment because you're a man or because you're a woman.
Yeah.
But it has specific carve-outs for women. It has carve-outs for women who become pregnant. It has carve-outs for advancing the cause of women. It has a whole bunch of carve-outs in the Act that specifically mention the word women.
Yeah.
And if you take the Scottish Government's argument, all of those carve-outs will be denied to those females who get gender recognition certificates.
Yeah.
And it will be given to the males who get the gender recognition certificates.
Who don't need them.
Yeah, they can't become pregnant.
Yeah.
So the difficulty, so I mean, all in all, what ends up happening then is you look at what the bench did in response to this, and it seems to me that the court was quite convinced by the combination of Forum in Scotland and Sex Matters, and I don't think was particularly convinced by the Scottish government.
Right, so one of my questions was, these judges, there were 5 of them, right? And they may not be obviously as familiar with all the arguments or be looking into it for years.
Yeah.
Did they get it?
I think some of them started out
struggling to differentiate how the law used to be, which was very much focused on surgery.
Yeah.
And were thinking that a gender recognition certificate are tied to surgery.
Yeah.
And I think there was a moment in the hearing when it became very clear that there was no requirement whatsoever to undergo any surgery.
Yeah.
At which point the question of what it is to live as a woman occupied the mind of several judges, and they asked an awful lot of questions about this. What does it mean to live as a woman? And the response, the accurate legal response based on what our current law says, is you have to have documents. You have to have a driving license that says F on it. You have to have a passport, because you can get these without getting
Without, yes, you can basically self-ID into a sex class already.
Yeah, for those very these are not representations of your legal status. They're just documents that you have.
Yeah.
But in practice that can create problems. But the point that that council agreed on was that none of this is about your appearance. It's all of it is just about your documentation.
Yeah.
And in fact, there was a case, AB, against the Gender Recognition Panel, which established not just that you only need documents, but AB was male to female in this legal framework who made a conscious decision that they wanted to keep a functioning penis and still live as a woman.
That was a legal argument.
Yeah, and it was accepted.
Oh wow!
So living as a woman is compatible with having a functioning penis.
Yeah.
And that,
oh my god,
that was a point that Aidan O'Neill made in his closing, and I think this is the point where the court at this point.
I'm laughing because it becomes so bizarre.
Yeah. But the court very quickly came to became very quickly up to speed with the reality on the ground that this certificate, you can have a gender recognition certificate and have no outwardly different appearance from you or I.
You and I, we're both blokes. You could have a certificate with an F on it, and I could not.
Yeah. Yeah.
You're a woman.
Well, the question is whether or not Parliament intended that to apply in the context of the Equality Act.
Right. Okay.
Would I be able to benefit from...
Even with your certificate, right?
Even with the certificate, would I be able to benefit from measures designed to increase the representation of women on company boards?
Yes.
And that was another thing. I mean, the court was very acutely aware of the fact that, the judges raised this point. This wasn't something that was raised by counsel, that you could be a man who had risen to the top of your career, and by at 50 years of age transition and get a certificate, and could then be counted as a woman for the purposes of the quotas on company boards.
Yes.
And the court seemed to be of the view that this would be fundamentally at odds with the purpose of the representation of women on company boards in the first place.
Yeah.
The point of this is to bear in mind the institutional disadvantage faced by women.
Which is the case that Aidan made in his on Tuesday when he made all the points about patriarchy.
Yes.
And he kept doing that.
Mm-hmm.
He said something and they went, patriarchy.
Yes.
Another example, patriarchy.
Yes.
Because I always think of patriarchy as a feminist idea, from a feminist way analysis. So it was interesting to have him, and he even talked about that, right? I'm a bloke and I'm saying this.
Yeah, he's aware of that.
When I'm representing women. So you were in there for 2 days, right? And is it like really like at one point do you kind of go, that's the gender fairy, the special message.
We'll close quickly, right?
Oh no, there's so much more that I wanted to talk about. But what was it like being in that space for 2 days and hearing all these arguments go back and forth? Was it like you were relishing being there?
I was absolutely exhilarated. This is an area of law I've been thinking about, writing about, publishing on for 2 years now. It was really, really interesting to see how all of those arguments were being made. I got to see, my own work was cited before the court. Aidan O'Neill made a pretty extensive quote from some of my own academic analysis. So, that was a real career highlight for me. It was great. And there's things that you can see from being in the room and looking at how the court is reacting that you couldn't see on the live stream.
Right.
And so you got a feel for the vibe in the room, if that makes sense.
Okay.
Yeah.
So how long will it take for them to come back with a judgment? Usually take a few months.
Yeah, this will be a few months. I wouldn't expect anything within 3 months. I think it'll be at least 3 months.
And from having been in that room for 2 days and got sort of gauged the questions that the judges asked and their understanding of it, what outcome are you expecting rather than hoping for, but in terms of just being really dry about the law? Which way do you think this is going to go?
I'd be based on all of that. I would be very, very surprised if the Scottish government wins. Now, there's things that can happen between now and then. You know, we've heard the oral submissions. The court seemed very convinced by, I think in particular, Sex Matters intervention. They said at the end, when Sex Matters had finished their oral submissions, the President of the Supreme Court thanked them expressly and said that it's been extremely helpful for them. So that's good. And also, I think was not convinced by the Scottish government's argument.
Right.
Now, a lot can happen between now and then. They're going to go back and look at the written arguments. They're going to think and ponder the written submissions, and they will have discussions among themselves about where the court is on different things. And we might have a single author judgment. We might have a dissent. There might be disagreement among the court.
Single author means it's unanimous?
Yeah.
Okay.
So we could have that. But basing, just on what the court has done there in the last 2 days, I would be very surprised if the Scottish government won.
Well, this is music to my ears, but we'll have to wait and see.
Yes.
And one thing that is for sure is this is now firmly on the political map, on the legal map. It's something that's definitely not going to go away.
Yeah, I mean, whatever the outcome of this decision will be, it will be the touchstone for the law in this area for the next 10 years at least.
Wow.
Say. Yeah.
Wow, and you've been part of that.
Yeah, it's quite a big thing, I think. I'm very, very, very happy to have been part of it.
Right, so the other thing that I wanted to talk about was, in case the judgment goes the other way, how legally can we sort out this mess? But I guess there's going to have to be a part 2.
Yeah, I think we should do a part 2. Part 2 would be good.
We should do a part 2 specifically about the different approaches to untangling the mess that we're in already, because sometimes I look at this and I think it's already gone way too far and too much has already been lost, and whatever we have on the basis of sex. I mean, Robin Moore-White wrote a whole piece in The Independent, there's no such things as sex-based rights, or if you say that, then it means you know nothing, and it's like...
And not just legally illiterate. I mean, we know that there are sex-based rights in
that
in
man
UK
is
law.
just something else. So let's do another one where we specifically look at repealing the GRA. What are the mechanisms? What would be the consequences, positive as well as negative? And is it even possible? Or should we focus on clarifying the Equality Act? Or is there another way? What is the role of international law? And what are we tied to in the UK? And when can we just go... This is my legal language.
That sounds like a great idea.
But thank you so much.
Oh, well, thank you so
I
much
mean,
for
how long have
having
we been talking? Well, just over an hour and
Yeah.
15 minutes.
It's been good. It's been good.
It's so good just to sit down and go through the history of it, and the different arguments that are being made. So, what are your hopes and ambitions for 2025? Because this has been quite a year for you.
I'm going to finish writing my book.
Your second book?
Yes, my second book, Sex, Gender Identity and the Law, shall be published with Cambridge University Press hopefully next year.
Does that have an international focus or a UK focus?
It'll mostly be a UK focus.
Okay.
But it'll be a very detailed and hopefully accessible to a public audience focus.
Okay.
Yeah.
Hope so.
I hope so too.
Right. So everyone, we're gonna go. We're gonna go and have a Sex Matters party, which isn't what it might sound like to people who don't know what the organization Sex Matters is. It's not a gay orgy.
Oh dear God.
Far from it. We'll do that on Saturday. Anyways, thank you so much.
Turn the camera off.
See you in the next one. Ciao. Thank you so much for watching, and thank you to my PayPal and Patreon supporters. Because of you, I can make videos like this.
Special shout out to my big spenders. Help Her Open, Mama Turv and the Turventines, Me Julie, The Lovely Mary, Julia, Dusty, Judels, Leffy, Dorothy, Wildfire, Esther, and Martha. Thank you.